In this video, I'll talk about legal challenges of critical race theory. Recently, there has been a lot of controversies surrounding critical race theory. I'll first talk about legal challenges of critical race theory at the federal and state level. I'll then briefly discuss the history of critical race theory and the tenets of the theory. Whether you agree with critical race theory or not, it's up to your own judgment. The U.S. Supreme Court justices wrote in the majority opinion of the Tinker case, "The classroom is particularly the marketplace of ideas. The nation's future depends upon leaders trained through wide exposure to that robust exchange of ideas which discovers the truth out of a multitude of tongues, rather than through any kind of authoritative selection." So I believe education is not about what to think, but how to think. In September 2020, President Trump issued an executive order excluding from federal contracts any diversity and inclusion training interpreted as containing divisive concepts, race or sex stereotyping, and race or sex scapegoating. On September 4, 2020, Office of Management and Budget Director released a memo directing all agencies to begin to identify all contracts or other agency spending related to any training on critical race theory, white privilege, or any other training or propaganda effort that teaches or suggests either that the United States is an inherently racist or evil country, or that any race or ethnicity is inherently racist or evil. The divisive, false, and demeaning propaganda of the critical race theory movement is contrary to all we stand for as Americans and should have no place in the federal government. Trump's ban was blocked by a federal judge in December 2020. After taking office, President Biden overturned the ban on critical race theory in January 2021. On May 12, 2021, Representative Greg Murphy introduced the Fight Radicalization of Elementary Education Act, which will prohibit the Department of Education from encouraging school districts to adopt critical race theory curriculum using federal grant funding. The bill reads, "No officer or employee of the federal government shall condition or incentivize the receipt of any grant, contract, or cooperative agreement upon a state, local educational agency, or school's adoption or implementation of specific instructional content, academic standards, and assessments, curriculum, or program of instruction related to the teaching of critical race theory." There has been reports that lawsuits related to critical race theory have been filed in different states. Those cases were about school districts' alleged race-based discrimination against white people. For example, the statement under question was a school district's equity trainer said, "White colleagues must take a step back and yield to colleagues of color." Another lawsuit was about students who were taught that reverse racism doesn't exist and that people of color cannot be racist. The U.S. Constitution does not mention education, and the public education system are established by individual state constitutions. State constitutions require their state legislative bodies to establish systems of public education. For example, the Constitution of the State of Georgia reads, "The provision of an adequate public education for the citizens shall be a primary obligation of the state of Georgia. Public education for the citizens prior to the college or post-secondary level shall be free and shall be provided by taxation." and the General Assembly may by general law provide for the establishment of education policies for such public education. When it comes to public school curriculum, state and local school boards have the control. The influence from the federal government is very limited. It can influence curriculum only through the federal aid it provides. For example, the Fight Radicalization of Elementary Education Act reads, no officer or employee of the federal government shall condition or incentivize the receipt of any grant, contract, or cooperative agreement related to the teaching of critical race theory. State legislatures, on the other hand, have the responsibility for curricular determinations and impose curriculum directives, but they must not violate federal constitutional rights. In Utah, the Utah Board of Education says critical race theory falls under curriculum, which is governed by each school district. When a group of parents planned to ask the school board not to teach critical race theory, the district spokesman said critical race theory is not part of the curriculum being used by the district, and there are no plans to incorporate it into their curriculum or instruction. Idaho governor signed House Bill 377. According to the bill, the Idaho legislature finds that the tenets outlined in subsection 3A of this section, often found in critical race theory, undermine the objectives outlined in subsection 1 of this section and exacerbate and inflame divisions on the basis of sex, race, ethnicity, religion, color, national origin, or other criteria in ways contrary to the unity of the nation and the well-being of the state of Idaho and its citizens. The bill then says no public institution of higher education, school district, or public school, including a public charter school, shall direct or otherwise compel students to personally affirm, adopt, or adhere to any of the following tenets. First, that any sex, race, ethnicity, religion, color, or national origin is inherently superior or inferior. Second, that any individuals should be adversely treated on the basis of their sex, race, ethnicity, religion, color, or national origin. Or third, that individuals by virtue of sex, race, ethnicity, religion, color, or national origin are inherently responsible for actions committed in the past by other members of the same sex, race, ethnicity, religion, color, or national origin. On May 11, 2021, Texas House voted 81 to 52 and passed House Bill 3979. Unlike the bill in Idaho, the bill in Texas did not single out the critical race theory. Here is the text regarding race. No teacher, administrator, or other employee in any state agency, school district, campus, open enrollment charter school, or school administration shall require or make part of the course the following concepts. First, one race or sex is inherently superior to another race or sex. Second, an individual, by virtue of his or her race or sex, is inherently racist, sexist, or oppressive, whether consciously or unconsciously. Third, an individual should be discriminated against or receive adverse treatment solely or partly because of his or her race or sex. Fourth, members of one race or sex cannot and should not attempt to treat others without respect to race or sex. Fifth, an individual's moral character is necessarily determined by his or her race or sex. Sixth, An individual, by virtue of his or her race or sex, bears responsibility for actions committed in the past by other members of the same race or sex. Seventh, any individual should feel discomfort, harbor guilt, anguish, or any other form of psychological distress on account of his or her race or sex. Or eighth, meritocracy or traits such as a hard work ethic are racist or sexist or created by members of a particular race to suppress members of another race. Amid all those controversies, what is critical race theory exactly? Are the descriptions provided by legislators and media accurate? Here I present a brief history of critical race theory and the tenets of the theory. You make your own judgment. The origin of critical race theory in education can be traced back to critical race legal scholarship. Critical race legal scholarship was developed in the 1970s. Derek Bell has been considered as the most influential source of thought critical of traditional civil rights discourse. Bell was an American lawyer, professor, and civil rights activist. Much of Bell's legal scholarship was influenced by his experience as both a black man and as a civil rights attorney. He examined the racial issues within the context of their economic, social, and political dimensions from a legal standpoint. Bell developed three major arguments in his analysis of racial patterns in American law. The first argument is constitutional contradiction. The second argument is the interest convergence, which suggests that whites will promote racial advances for blacks only when they also promote white self-interest. The third major argument is the price of racial remedies. Bell argued that whites will not support civil rights policies that may threaten white social status. In 1973, Bell published a book titled Race, Racism, and American Law. The book has been considered foundational in the field of critical race theory. Bell examined the events leading up to the Constitution's development and concluded that there exists a tension between property rights and human rights. The framers of the Constitution chose the rewards of property over justice. The American history is filled with tensions and struggles over property, from the removal of Indians and later Japanese Americans from the land, to military conquest of the Mexicans, and to the construction of Americans as property. A central feature of power in America has been the ability to define, possess, and own property. And a government constructed to protect the rights of property owners lacked the incentive to secure human rights. This tension between property rights and human rights was greatly exacerbated by the presence of African peoples as slaves in America. Bell further argued that the purpose of the government was to protect the main object of society, which was property. The slave status of most African American, as well as women and children, resulted in their being objectified as property. And a government constructed to protect the rights of property owners lacked the incentive to secure human rights for the African American. Due to civil rights leaders' limited focus on the tension between property rights and human rights, despite the Brown versus Board of Education decision, Bell considered the aftermath of Brown as a disappointment because it produced detrimental repercussions for black students who remained to be seen as inferior to white students. Desegregation did not undo the injustices set by segregation in the first place, but instead create a whole new set of problems for black students attending predominantly white schools. Bell concluded that the focus for American educational system should not be on national integration, but rather should be on improving the quality of education provided for Black students. Over the years, critical race theory has branched into more theories describing the hardships of other races and gender to address racism beyond the black-white binary. Recently, scholars proposed disability critical race theory. Disability critical race theory focuses on how perceptions about race often influence how one's ability in thinking, learning, and behavior is imagined, surveilled, and evaluated. There are many influential scholars of critical race theory, including but not limited to Cheryl Harris, Kimberly Crenshaw, and many others. In the 1990s, critical race theory was introduced to education. In this 1995 article published in the Teachers College Record, Gloria Ladson-Billings and William Tate developed three propositions. First, race continues to be significant in the United States. Second, U.S. society is based on property rights rather than human rights. And third, the intersection of race and property creates an analytical tool for understanding inequity. To support the first proposition that race continues to be significant in explaining inequity in the United States, Ladson-Billings and Tate used two meta-propositions. First, race, unlike gender and class, remains untheorized. Second, class and gender-based explanations are not powerful enough to explain all of the differences or variance in school experience and performance. To support the second proposition that U.S. society is based on property rights rather than human rights, Ladson-Billings and Tate borrowed critical race legal scholarship. They cited Bell's work, which argued that when civil rights leaders of the 1950s and 1960s built their pleas for social justice on an appeal to the civil and human rights, they ignored the fact that the society was based on property rights. In education, part of district revenue comes from property tax. Affluent communities have higher property values, hence higher tax assessments. Likewise, curriculum represents a form of intellectual property. The quality and quantity of the curriculum varies with the property values of the school. To support the third proposition that the intersection of race and property creates an analytical tool for understanding inequity, Ladson-Billings and Tate use the term property functions of whiteness. This term came from Cheryl Harris' analysis of whiteness as property. Harris wrote, slavery linked the privilege of whites to the subordination of blacks through a legal regime that attempted the conversion of blacks into objects of property. Similarly, the settlement and the seizure of Native American land supported white privilege through a system of property rights in land, in which the race of the Native Americans rendered their first possession right invisible and justified conquest. To apply Harris' analysis of whiteness as property to explain education inequity, it is argued that white property is being rendered alienable when students are rewarded only for conformity to perceived white norms or sanctioned for cultural practices. It is therefore called rights of disposition. Regarding rights to use and enjoyment, Ladson-Billings and Tate argue that whiteness allows for specific social, cultural, and economic privileges. As for reputation and status property, Ledson, Billings, and Tate argue that to damage one's reputation is to damage one's aspect of his or her personal property. In the case of race, to call a white person black is to defame him or her. In education, urban schools lack status and reputation of suburban schools. When urban students move to or were bused to suburban schools, urban schools lose their reputation. Regarding the absolute right to exclude, Ledson, Billings, and Tate argue that in education, the absolute right to exclude was demonstrated initially by denying blacks access to schooling. Later, it was demonstrated by the creation and maintenance of separate schools. More recently, it has been demonstrated by white flight and the growing insistence on vouchers, public funding of private schools, and schools of choice. Within schools, absolute right to exclude is demonstrated by resegregation via tracking the instruction of gifted programs, honors programs, and advanced placement classes. In this video, I discussed some of the legal challenges surrounding critical race theory at the federal and state levels. I also presented a brief history of critical race theory and the tenets of the theory. Whether you agree with critical race theory or not, it's up to your own judgment. I believe education is not about what to think, but how to think.